Hello and welcome to this episode of TaxSnax from Old Square Tax Chambers. This is an episode in our series on litigating against HMRC, and in this episode I'm talking about the examination of expert witnesses. Now, this is a topic that commonly arises in litigation generally. The reason why it's quite important when you're litigating against HMRC is because you tend to get, in particular, one type of expert evidence that we see an awful lot of, and that is evidence on proper accountancy treatment. So being able to examine experts is an important part of litigating in circumstances where your opponent is HMRC, or indeed where the subject is taxation. So first of all, what is an expert? An expert is a person who can explain a particular field to the judge or to the tribunal and can give evidence on that. They are an expert in that field, and their opinion on the situation is the expert evidence that they give. So they're an unusual example of an witness of fact who can in fact give opinion evidence. As I've said, the key way this is going to arise in the tax tribunals is through accountancy evidence. Other areas that might be relevant, evidence of foreign law, I'm going to come back to that in a minute, and sometimes statistical evidence is going to come up as well. So now you might say, well, foreign law, that's a matter of law, not fact. Foreign law is a matter of fact because the tribunals of this country are not tribunals to adjudicate that law. So if, for example, the taxation in question turns on how a foreign law instrument is interpreted under that law, then what you need to do is you need to have a foreign lawyer from that jurisdiction come in and give evidence on what that law says about that particular type of instrument, for example. So those are the types of law that we're most commonly going to see. Now, before we get on to the particular intricacies of dealing with expert evidence, I want to first of all draw your attention to some of the procedural issues. So it follows naturally that if you can't get the basic procedural issues right, it isn't going to matter how well you do the actual job. So it's important to make sure that you followed the process. Now, the first tier tribunal rules are a bit light on process for expert evidence. It's just rule 15(1)(c), which says that the tribunal can give directions as to whether or not expert evidence is to be provided, and whether it's by a jointly appointed expert or whether the parties can have an expert each. Frequently it's going to be an expert each rather than a joint expert. And so there's not much else said about expert evidence in the tribunal rules. However, what the first tier tribunal tends to do is to fall back on the civil procedure rules, part 35, which is the part of the CPR that governs expert evidence in the county courts and high court. So, what might we see procedurally that comes out of part 35? Well, first of all, this tells us that the expert's duty, their first duty, is to the court, irrespective of who is paying them. So a bit like being a barrister, you can't just say anything because you have a duty to the court. So you can't, for example, tell the court something that's untrue because your client wants you to. Neither can an expert witness. So that's the first point. And I'm going to come on to something in a minute which is going to make you think that perhaps that's not very clear-cut. Realistically, experts are, to a certain extent, guns for hire. And so, to a certain extent, they are going to struggle with that duty, but the duty is there and they should try to follow it. Second, Rule 35.5. As with most witness evidence in the first tier tribunal, it's usual for expert evidence in chief to be given in a written report. 35.6, generally where there's been a written report, the parties get the opportunity to ask questions in writing of the experts on that written report. They should generally be only of a clarificatory nature. Any expert report has to be compliant with Practice Direction 35. I'm not going to take you through the requirements, but remember it's there and make sure your experts comply with it. If you're using somebody who has given expert evidence before, they should absolutely know about this, but still you may want to send them a copy of it or set out the requirements of it in your instructions so that they know what the report has to include in order to comply. The next one is 35.10, and this is very important. The expert report has to state the substance of the instructions that they were given to produce it. And this is for obvious reasons, because by asking the right questions, in inverted commas, you can get to the answer that you want to get to. So it's important for the court to be able to see that the expert hasn't done that, or indeed that the party in question hasn't done that. So I've already said that with experts in the tax tribunal, generally you're going to have an expert each. Using a joint expert is tricky. Where you do have a joint expert, you very much need to make sure that your preparation is better than the preparation of the other side. So in terms of the process of dealing with expert reports and expert witnesses, because ultimately we're going to be cross-examining the other side's expert, I take the approach of what we do with your expert and what we do with their expert. And counterintuitively, I'm going to start by talking about what we might do with their expert, because that then informs how we want to interact with our expert. So starting with their expert, what are the things that you want to draw out in cross-examination? The first one is on what facts is their opinion predicated. So what were they told is the factual situation? Usually that will be HMRC's version of the facts, so the factual case that they put forward. What you can then do, which very gently potentially undermines an expert, is ask them about how that view would change if the factual scenario changed. Say if it was a bit more like the factual scenario that the taxpayer is putting forward. And so if it would be different, then that's obviously a point that you need to draw out. The other point that you need to draw out, which can be trickier, also if there is anything in an expert report which is factually inaccurate. So for example, there is an agreed fact and the expert has got that wrong. I once cross-examined an expert who thought that a sole trader was a partnership, which was not a good start for their report. But where you have something like that, you also need to draw that out and then ask how the fact that they've got that incorrect is going to impact on their conclusions. The next thing to draw out is what inferences have they made and how do those inferences affect the decision. So inferences are things that they have assumed based on the facts that they have been given. And this can be very important because in two ways. First, the inferences may not be correct, and then the same applies as to the situation where a fact is not correct. But secondly, the inference may not be an appropriate inference at all, and where the expert has drawn an inference that you wouldn't expect them to, that can be drawn out because that may undermine them altogether. The other thing that you may wish to do with your opponent's expert in cross-examination is attack their qualification. Now, this needs to be done carefully, politely, and kindly. It's important to remember, however engaged we are in a case, that when you're dealing with witnesses, you're dealing with people who go home at the end of the day and feed their kids and feel bad if they've done badly, and who feel upset if people suggest they're not as qualified as they are. It never hurts to be a human being, and in fact it hurts not to be one. So when you're doing something like attacking qualification, do it with empathy. So some of the things that you can look at here is your expert more qualified than their expert? And if they are, you can draw that out. Are they the right expert at the right time? So again, once in an MTIC fraud case, I cross-examined an expert, and she was an expert statistician, and she very much was an expert statistician. However, she did not have the requisite expertise to deal with the tax consequences of the statistical outcomes, and that's what she was opining on ultimately, was what the statistics showed in relation to the tax effects. Now, if I could go back, I would like to do that again with much greater kindness and much greater empathy, but it was a valid strategy to show that the expert wasn't the right expert. She was great on the statistics, she wasn't great on the tax. So that's another thing that you can do. Now, another approach that you can take, but you want to think very carefully before you do this, is to look at whether or not their expert might have bias, whether conscious or unconscious. And this is particularly pertinent in the context of tribunal proceedings against HMRC, because frequently when HMRC appoint an expert, they appoint somebody who is employed by HMRC. Now, there is a clear risk of conscious bias where your employer pays, where the person who pays your wages is the person whose case you're being asked to comment on, in effect. But of course you have that same situation because an independent expert will be paid by the person for whom they're producing the report for the taxpayer. So you have a similar, though not quite the same situation, because of course the independent expert walks away after writing one report for the taxpayer. The employee of HMRC not only is paid on an ongoing basis by HMRC, but also there's a possible risk of them saying, if they say the wrong thing, of that affecting their career path. Now, the reason I say you have to be very careful before you take this route is because tribunals do not like it. They consider, generally speaking, that HMRC staff are able to separate out their personal position as an employee of HMRC from their duty to the court, and I'm sure in very many cases that's right. The better approach may be to suggest unconscious bias. So to give an example of how one might do that, going back to my fraud case, we had other experts who came in to opine on certain aspects of how trading went, but these experts had always worked for HMRC. They had always been investigating people who HMRC suspected weren't paying the right amount of VAT, and therefore it can be seen that after 20 or 30 years of that sort of career, they might naturally be expected to see fraud or irregularity where another person might not. That's a gentler approach. Again, I'm not necessarily saying that it finds great favour in front of a tax tribunal, but it's certainly something to consider. Now, having talked about the sort of things that one might try to draw out with HMRC's expert, it's time to turn to what we're going to do with our expert. So, assuming that the other side is going to do something fairly similar, there are certain things that we need to do. The instructions to the expert need to be very carefully considered. It isn't right or fair or in furtherance of the overriding objective to seek to prevent information to seek to get the right answer from an expert. So the important thing is to set out all of the facts that you think are relevant, but also all of the facts that the other side think are relevant, or that you think they think are relevant, degrees of intention, because then hopefully when your expert is cross-examined, they aren't going to be caught out by the technique of saying, well, what if the facts were this? we want them to consider all of the facts, not just the facts as we hope they might come out. So that's the first thing. In considering your instructions, you also need to consider the way in which the questions that you put to the expert are put and all of the procedural requirements. But certainly make sure that the expert covers everything that you need them to cover. Give them as much factual background as you can in order to ensure that they can't be put in the position where they will have to concede that the position would be different if the facts were different. So don't give them a very narrow scope of facts necessarily. And also make sure you've covered all your procedural ground as mentioned previously. So practice direction 35, very important. So then we've talked about how one might seek to undermine the evidence of an expert by undermining their qualification. So one of the things to think about is, why is your expert better than their expert? Are they more qualified? Do they have more experience? If they're not, and or they don't, why should the judge prefer your expert? So you may need your expert to be very careful about the way they present their report. You may need them to be very careful about the way they present themselves in court as well. Now, one of the things that you will do with an expert is you will meet with them before you go to court and before you cross-examine HMRC's expert and before they are cross-examined. Now, of course, all the normal rules apply, certainly for barristers, so one cannot prepare a witness. However, you can use your expert to help you prepare for your cross-examination of their expert. So what do we want to do? First of all, we go into any meeting with an expert with as much knowledge and understanding of the issues covered by the expert reports as is possible. So that means you might have had to do quite a lot of background reading and develop knowledge in this area, even if it's very narrow and specific. So when you go in, you don't want to sort of say to the expert, well, I don't understand this, what's it all about? You want to be saying, so when we get to here, what I don't understand, and can you please explain to me, is how A affects B in the context of this accounting principle, or something like that. You want to have very specific, focused questions because you understand the background. So that is the first thing. You're looking to clarify what you don't understand, but before you meet with the expert, make sure you have clarified as much of what you don't understand as you can by yourself. This has an additional benefit, which is when you're questioning an expert, you want to use the right language, you don't want to be corrected by them, and you want to look like you have a good understanding of what's going on, and therefore you need this background anyway. So make sure that you're looking to clarify the last few points that you don't understand, not just asking them to give you a masterclass in whatever their specialist subject is. So that's that. The other thing I would suggest is asking all of these questions. So ask the expert, who is better, you or them? Who looks better on paper? Why is that wrong? How can I prepare the judge who might think, well, their expert is better? Or, if you're better, how can we highlight that to the judge? So that's the first question to ask. The second question you want to ask them is, on the technical expert evidence, what's our best point? What are we focused on? What can we win on? Also, what is their worst point? So where does the expert think they can be undermined in terms of their report? Indeed, ask the expert, how do we undermine what they're saying here? What would you say? Why is your position better than their position? And how do we undermine that position using that? And then you want to ask them, how do we win? What do we need to do to win on the expert evidence? So once you have all that, you can start preparing for cross-examination, and this is an area where you need to prepare really thoroughly because you're trying to look educated in the area, maybe not an expert, but somebody who's spent a lot of time boning up on it for this particular hearing. So I'd suggest writing the questions for your cross-examination in advance. All the usual rules on cross-examination apply, but you want short, pithy questions. You want 1 point per question, particularly if it's very technical expertise, and you want to use the language of the experts, and you want to make sure you get that terminology correct. So when you actually get to court, be polite, be kind, have empathy if you're having to try and undermine someone. Use the expert language. And one other thing, look for grey areas. In most fields of expertise, it's not cut and dry. So it may be that even if you can't get the expert to fall over and say they're wrong and your expert is right, I'm not sure that's ever happened. Certainly never happened to me. But even if you can't do that, what you want to do is highlight grey areas and ask them to agree with you that, well, they think they are correct. They can't absolutely say that your expert is incorrect. So, i.e. that there's a spectrum of opinion on that matter, and both their opinion and your expert's opinion are within that reasonable range. So, expert evidence can be essential, and particularly when it's accountancy evidence, it can be make or break for a case. Some aspects of taxation turn almost wholly on the accountancy treatment, and when that is the case, we really need to understand what those principles are, how they apply, and why they apply so the taxpayer wins, or if you're acting for HMRC, so that HMRC wins. So I hope you've enjoyed that brief run through of dealing with expert evidence. Look out for our future series and episodes of TaxSnax. Thank you.